Informed consent, all about medical sociology and medical procedures. This is printed in Wikipedia. Medical sociologists have studied informed consent as well as bioethics more generally. Una Corrigan, looking at informed consent for research in patients, argues that much of the conceptualization of informed consent comes from research ethics and bioethics with the focus on patient autonomy, and notes that this aligns with a neoliberal worldview. Corrigan argues that a model based solely around individual decision-making does not accurately describe the reality of consent because of the social processes, a view that has started to be acknowledged in bioethics. She feels that the liberal principles of informed consent are often in opposition with autocratic medical practices, such that norms, values, and systems of expertise often shape an individual's ability to apply choice. Patients who agree to participate in trials often do so because they feel the trial was suggested by a doctor as the best intervention. Patients may find being asked to consent within a limited time frame a burdensome intrusion on their care when it arises because a patient has to deal with a new condition. Patients involved in trials may not be fully aware of the alternative treatments, and an awareness that there's uncertainty in the best treatment can help make patients more aware of this. Corrigan notes that patients generally expect that doctors are acting exclusively in their interest in their interactions, and that this combined with clinical equipoise where a healthcare practitioner does not know which treatment is better in a randomized controlled trial can be harmful to the doctor-patient relationship. Medical procedures. The doctrine of informed consent relates to professional negligence and establishes a breach of the duty of care owed to the patient. See duty of care, breach of conduct, and duty and respect for persons. The doctrine of informed consent also has significant implications for medical trials of medications, devices, or procedures. Requirements of the professional. Until 2015, the United Kingdom and the countries such as Malaysia and Singapore, informed consent in medical procedures requires proof as to the standard of care to expect as a recognized standard of acceptable professional practice. That is, what risks would a medical professional usually disclose in the circumstances? Arguably, there's a sufficient consent rather than informed consent. The UK has since departed from the Bolam test for judging standards of informed consent due to the landmark ruling in Montgomery versus Lancashire Health Board. This moves away from the concept of a reasonable physician and instead uses the standard of a reasonable patient and what risks an individual would attach significance to. Medicine in the United States, Australia, and Canada take this patient-centric approach to informed consent. Informed consent in these jurisdictions requires healthcare providers to disclose significant risks, as well as risks of particular importance to that patient. This approach combines an objective, a hypothetical reasonable patient, and subjective, this particular patient approach. Optimal establishment of an informed consent requires adaptation to cultural or other individual factors of the patient. As of 2011, for example, people from Mediterranean and Arab backgrounds appeared to rely more on the context of the delivery of the information, with the information being carried more by who is saying it and where, when, and how it is being said, rather than what is said, which is of relatively more importance in typical Western countries. The informed consent doctrine is generally implemented through good healthcare practice, pre-operation discussions with patients, and the use of medical consent forms in hospitals. However, reliance on a signed form should not undermine the basis of the doctrine and giving the patient an opportunity to weigh and respond to the risk. In one British case, a doctor performing routine surgery on a woman noticed that she had cancerous tissue in her womb. He took the initiative to remove the woman's womb. However, as she had not given informed consent for the operation, the doctor was judged by the General Medical Council to have acted negligently. The council stated that the woman should have been informed of her condition and allowed to make her own decision. Obtaining informed consents. To document that informed consent has been given for a procedure, healthcare organizations have traditionally used paper-based consent forms, on which the procedure and its risks and benefits are noted and assigned by both patient and clinician. In a number of healthcare organizations, consent forms are scanned and maintained in an electronic document store. The paper consent process has been demonstrated to be associated with significant errors of omission, and therefore increasing numbers of organizations have used digital consent applications where the risk of errors can be minimized. A patient's decision-making and comprehension can be supported by additional lay-friendly and accessible information, and consent can be completed remotely, and the process can become paperless. In one form of digital consent is dynamic consent, which invites participants to provide consent in a granular way and makes it easier for them to withdraw consent if they wish. Patient satisfaction in the context of novel forms of informed consent has been a topic in scientific research. Visual and auditory components in video-assisted informed consent and digital informed consent have proved to lead to higher patient satisfaction. Integrating patients into treatment decisions, shared decision-making, and increasing transparency leads to better overall treatment adherence. Electronic consent methods have been used to support indexing and retrieval of consent data, thus enhancing the ability to honor a patient intent and identify willing research participants. More recently, Health Sciences South Carolina, a statewide research collaborative focusing on transforming healthcare quality, health information systems, and patient outcomes, developed an open source system called Research Permissions Management System, RPMS. Competency of the patient. The ability to give informed consent is governed by a general requirement of competency. In common law jurisdictions, adults are presumed competent to consent. This presumption can be rebutted, for instance, in circumstances of mental illness or other incompetence. This may be prescribed in legislation and based on a common law standard of inability to understand the nature of the procedure. In cases of incompetent adults, a healthcare proxy makes medical decisions. In the absence of a proxy, the medical practitioner is expected to act in the patient's best interest until a proxy can be found. By contrast, minors, which may be defined differently in different jurisdictions, are generally presumed incompetent to consent, but depending on their age and other factors may be required to provide informed assent. In some jurisdictions in much of the U.S., there is a strict standard. In other jurisdictions, England, Australia, Canada, this presumption may be rebutted through proof of the minor is mature, the Gillick standard. In cases of incompetent minors, informed consent is usually required from the patient rather than the best interest standard, although a parent's order may apply, allowing the court to dispense with parental consent in cases of refusal. Deception. Research involving deception is controversial given the requirement for informed consent. Deception typically arises in social psychology when researching a particular psychological process requires that investigators deceive subjects. For example, in the Milgram experiment, researchers wanted to determine the willingness of participants to obey authority figures despite their personal conscientious objections. They had authority figures demand that participants deliver what they thought was an electrical shock to another research participant. For the studies to succeed, it was necessary to deceive the participants. So they believed that a subject was a peer and that their electric shocks caused the peer actual pain. Nonetheless, research involving deception prevents subjects from exercising their basic right of autonomous, informed decision-making and conflicts with the ethical principle of respect for persons. The ethical principles of psychologists and code of conduct set by the American Psychological Association says that psychologists must conduct research that includes a deceptive compartment only if they can both justify and act by the value and importance of the study's results and show that they could not obtain the results in some other way. However, the research should bear no potential harm to the subject as an outcome of deception, whether physical pain or emotional distress, which certainly happened. Finally, the code requires a debriefing session in which experimental both tells the subject about the deception and gives the subject the option of withdrawing the data. Abortion. In some U.S. states, informed consent laws, sometimes called right-to-know laws, require that a woman seeking an elective abortion receive information from the abortion provider about her legal rights, her alternatives to abortion, such as adoption, available public and private assistance, and other information specified in the law before the abortion is performed. Other countries with such laws, such as Germany, require that the information giver be properly certified to make sure that no abortion is carried out for the financial gain of the abortion provider, and to ensure that the decision to have an abortion is not swayed by any form of incentive. Some informed consent laws have been criticized for allegedly using loaded language in the apparently deliberate attempt to personify the fetus. But those critics acknowledge that most of the information in the legally mandated materials about abortion comports the recent scientific findings and the principles of informed consent, although some content is either misleading or altogether incorrect. Within research, informed consent is part of ethical clinical research, as well as a human subject voluntarily confirms his or her willingness to participate in a particular clinical trial after having been informed of all aspects of the trial that are relevant to the subject's decision to participate. Informed consent is documented by means of written, signed, and dated informed consent forms. In medical research, the Nuremberg Code sets a base international standard in 1947 in response to the ethical violation of the Holocaust. Standards continue to develop, and nowadays medical research is overseen by an ethics committee that also oversees the informed consent process. Social sciences. As the medical guidelines established in the Nuremberg Code were imported into the ethical guidelines for social sciences, informed consent became a common part of the research procedure. However, while informed consent is the default in medical settings, it's not always required in social sciences. Here, firstly, research often involves low or no risk for participants, unlike in many medical experiments. And second, the mere knowledge that they participate in a study can cause people to alter their behavior, as in the Hawthorne effect. In the typical lab experiment, subjects enter an environment in which they are keenly aware that their behavior is being monitored, recorded, and subsequently scrutinized. In such cases, seeking informed consent directly interferes with the ability to conduct the research because the very act of revealing that a study is being conducted is likely to alter the behavior studied. Author Jay List explains the potential dilemma that can result. If one were interested in exploring whether and to what extent race or gender influences the prices that buyers pay for used cars, It would be difficult to measure accurately the degree of discrimination among used car dealers who know that they are taking part in an experiment. In a case where such inference is likely and after careful consideration, a researcher may forego the informed consent process. And this may be done after the researchers in the ethics committee and/or institutional review board weigh the risk to study participants against the benefits to society and whether participants participate voluntarily or are to be treated fairly. The birth of new online media, such as social media, has complicated the idea of informed consent. In an online environment, people pay little attention to terms of use agreements and can subject themselves to research without thorough knowledge. This issue came to the public light following a study conducted by Facebook in 2014 and published by that company and the Cornell University. Facebook conducted a study without consulting an ethics committee, or RIB, where they altered the Facebook news feeds of roughly 700,000 users to reduce either the amount of positive or negative posts they saw for a week. The study then analyzed if the user's status updates changed during the different conditions. The study was published in the Proceedings of the National Academy of Sciences. The lack of informed consent led to outrage among many researchers and users. Many believe that by potentially altering the mood of users by altering what posts they see, Facebook put at-risk individuals at higher dangers for depression and suicide. However, supporters of Facebook claim that Facebook details that they have a right to use information for research in their terms of use. Others say that the experiment is just a part of Facebook's current work, which alters news feeds, this specific algorithms continually to keep people interested in coming back to the site. Others point out that this specific study is not unique, and rather that news organizations constantly try different headlines using algorithms to elicit emotions or garner clicks or Facebook shares. They say this Facebook study is no different from things people already accept. Still, others say that Facebook broke the law when conducting the experiment on users that did not give informed consent. The Facebook study controversy raises numerous questions about informed consent and the differences in the ethical review process between publicly and privately funded research. Some say Facebook was within its limits, and others see the need for more informed consent and/or the establishment of in-house private review boards. Duty to share findings. Some researchers and ethicists advocate for researchers to share experimental results with their subjects in a way they can understand, both as an ethical obligation and as a way to encourage more participation. In 2023, the government of the United Kingdom proposed making this a requirement. The Ethical, Legal, and Social Implications Research Program of the National Human Genome Research Institute in the United States has provided some funding for researchers to do this. Conflicts of interest. Other long-standing controversies underscore the role of conflicts of interest among medical school faculty and researchers. For example, in 2014, the coverage of the University of California medical school faculty members has included news of ongoing corporate payments to researchers and practitioners from companies that market and produce the very devices and treatments they recommend to patients. Robert Pedowitz, the former chairman of the ACLU's Orthopedic Surgery Department, reported concern that his colleagues' financial conflicts of interest could negatively affect patient care or research into new treatments. In a subsequent lawsuit about whistleblower retaliation, the university provided a $10 million settlement to Pedowitz while acknowledging no wrongdoing. Consumer watchdog and oversight group observed the University of California policies were either inadequate or unenforced. Patients in the University of California hospitals deserve the most reliable surgical devices and medication, and they shouldn't be treated as subjects in expensive experiments. Other University of California incidents include taking the eggs of women for implantation into other women without consent, and injecting live bacteria into human brains, resulting in potentially premature deaths. History. Informed consent is a technical term first used by attorney Paul G. Gephardt in the Salgo versus Leland Stanford Junior University Board of Trustees court case in 1957. In tracing its history, some scholars have suggested tracing the history of checking for any of the practices. A patient agrees to a health intervention based on an understanding of it. 2, the patient has multiple choices and is not compelled to choose a particular one. 3, the consent includes giving permission. These practices are part of what constitutes informed consent, and their history is a history of informed consent. They combine to form the modern concept of informed consent, which arose in response to particular incidences in modern research. Whereas various cultures in various places practice informed consent, the modern concept of informed consent was developed by people who drew influence from Western tradition. Medical history. Historians cite a series of medical guidelines to trace the history of informed consent in medical practice. The Hippocratic Oath, a Greek text dating to 500 BC, was the first set of Western writings giving guidelines for the conduct of medical professionals. Consent by patients, as well as several other now considered fundamental issues, is not mentioned. The Hippocratic Corpus advises that physicians conceal most information from patients to give the patients the best care. The rationale is a beneficence model of care. The doctor knows better than the patient and therefore should direct the patient's care because the patient is not likely to have better ideas than the doctor. Henry de Mondeville, a French surgeon who in the 14th century wrote about medical practice, he traced his ideas to the Hippocratic Oath. Among his recommendations were the doctor's promise a cure to every patient, in hopes that the good prognosis would inspire a good outcome to treatment. Mondeville never mentioned getting consent, but did emphasize the need for the patient to have confidence in the doctor. He also advised that when deciding therapeutically unimportant details, the doctor should meet the patient's requests so far as they do not interfere with treatment. In Ottoman Empire records that exist an agreement from 1539 in which negotiates details of a surgery, includes fee and a commitment not to sue in case of death. This is the oldest identified written document in which a patient acknowledges risk of medical treatment and rights to express their willingness to proceed. Benjamin Rush was an 18th century United States physician who was influenced by the Age of Enlightenment cultural movement. Because of this, he advised that patients ought to share as much information as possible with patients. He recommended that doctors educate the public and respect a patient's informed decision to accept therapy. There's no evidence that he supported seeking consent from patients. In a lecture titled On the Duties of Patients to Their Physicians, he stated that patients should be strictly obedient to the physician's orders, and this was representative of much of his writings. John Gregory, Rush's teacher, wrote similar views that a doctor could best practice beneficence by making decisions for the patients without their consent. And there we go. And it still goes on. Thomas Percival was a British physician who published a book called Medical Ethics in 1803. Percival was a student of the works of Gregory and various earlier Hippocratic physicians. Like all previous works, Percival's Medical Ethics makes no mention of soliciting for the consent of patients or respecting their decisions. Percival said that patients have a right to truth, but when the physician could provide better treatment by lying or withholding information, he advised that the physician do what he thought best. When the American Medical Association was founded in 1847, they produced a work called the first edition of the American Medical Association Code of Medical Ethics. Many sections of this book are verbatim copies of passages from Percival's Medical Ethics. A new concept in this book was the idea that physicians should fully disclose all patient details truthfully when talking to other physicians, but the text does not apply this idea to disclosing information to patients. Through this text, Percival's ideas became pervasive guidelines throughout the United States as other texts were derived from them. Worthington Hooker was an American physician who in 1849 published Physician and Patient. This medical ethics book was a radical demonstrating understanding of the AMA's guidelines and Percival's philosophy and soundly rejecting all directives that a doctor should lie to patients. In Hooker's view, benevolent deception is not fair to the patient, and he lectured widely on this topic. Makes you wonder about the people that have gotten into medicine in this country. Hooker's ideas were not broadly influential. The U.S. Canterbury versus Spence case established the principle of informed consent in U.S. law. Earlier legal cases has created the underpinnings for informed consent, but his judgment gave a detailed and thought-through discourse on the matter. The judgment cites cases going back to 1914 as precedent for informed consent. Research history. Historians cite a series of human subject research experiments to trace the history of informed consent in research. The U.S. Army Yellow Fever Commission is considered the first research group in history to use consent forms. In 1900, Major Walter Reed was appointed head of the four-man U.S. Army Yellow Fever Commission in Cuba that determined mosquitoes were the vector for yellow fever transmission. His earliest experiments were probably done without formal documentation of informed consent, and in later experiments he obtained support from one appropriate military and administrative authorities. He then drafted what is now one of the oldest series of extant informed consent documents. The three surviving examples are in Spanish with English translations. Two have an individual signature and one is marked with an X. Tea Room Trade is the name of a book by American psychologist Laud Humphreys. In it, he describes his research into male homosexual acts. In conducting this research, he never sought consent from his research subjects, and other researchers raised concerns that he violated the right to privacy for research participants. Henrietta Lacks on January 29, 1951, shortly after the birth of her son Joseph, Lacks entered Johns Hopkins Hospital in Baltimore with profuse bleeding. She was diagnosed with cervical cancer and was treated with inserts of radium tubes. During her radiation treatments for the tumor, 2 samples, one of healthy cells and one of malignant cells, was removed from her cervix without her permission. Later that year, 31-year-old Henrietta Lacks died from the cancer. Her cells were cultured, creating HeLa cells, but the family was not informed until 1973. The family learned the truth when scientists asked for DNA samples after finding that HeLa had contaminated other samples. In 2013, research published the genome without the Lacks family consent. The Milgram experiment is the name of the 1961 experiment conducted by American psychologist Stanley Milgram. In the experiment, Milgram had an authority figure order research participants to commit a disturbing act of harming other persons. After the experiment, he would reveal that he had deceived the participants and that they had not hurt anyone. but the participants were upset at the experience of having participated in the research. The experiment raised broad discussion on the ethics of recruiting participants for research without giving them full information about the nature of the research. Chester M. saw them use HeLa cells to inject other cancer patients and the Ohio State Penitentiary inmates without informed consent to determine if people could become immune to cancer and if cancer could be transmitted. With the growth of bioethics in the 21st century to include environmental sustainability, some authors, such as Christina Ricci, have proposed a green consent, which would include information education about the climate impact of pharmaceuticals, the common carbon cost of medication, and climate change health hazards.